Langley. You're here today for a probation hearing on your Lacey cases where you're on probation for assault, obstructing, theft, and violation of a protection order. All right, Ms. Langley, where are we at?
As to those cases, I think nothing is resolved yet. I'm still awaiting the outcome of those cases. I had them come up today because I think there's also a no contact order motion filed. So,
yeah. Okay, so those cases are still pending in Olympia.
Yes.
All right, let's see. I'm going to take a look at those and see when there's, let's see, pre-trials are coming up on the 6th, so that's next week. All right, and yes, I did get a request to take that order off, but not really inclined to do that when he's not in current compliance with his probation. I don't know, Mr. Sharp, have you got a position on that request?
Well, Your Honor, I apologize. I didn't catch that there was an order or a motion on that order today, so I would need a few minutes to review it, but just I'm highly skeptical there'd be anything in there to change the city's position. I think the court nailed it on the head. We have ongoing probation violations to address. That's certainly not a time to expose people to more risk. And I'd also point out that the new law violation situation here is fairly young, so we'd ask that the court set a PFTC rather than setting it for full FTC just right away. I think it hasn't even been a couple of weeks yet.
All right, and are you Shannon?
Yes.
Okay. All right. So did you hear what?
All right, guys, welcome to a heated courtroom moment. We're opening this intense probation hearing with a defendant facing serious charges: assault, theft, obstruction, and violation of a protection order. The tension is real. The judge is digging deep, calling out non-compliance, and the city prosecutor isn't letting anything slide. A request to drop a no-contact order. Denied. Compliance comes first, and violations won't be swept under the rug. The city's stance. Clear as day, this isn't the time to gamble with public safety. This courtroom means business, and they're not here to play games.
What Mr. Sharp just said there?
I did. I don't know what those letters mean, but can I address you, please? Because is that okay? Sorry.
Yeah.
Okay, so this is my son.
Well, before you do, though, would you have a seat there in front of that microphone, then everybody can hear you? Yeah.
Okay, thank you. Sorry. So that's my son. So the reason there's this order is because I lied. I mean, this is the second time I motioned to file it, but I couldn't, he had a warrant the first time, so I had to refile it right now to get this court date for this. I lied. I lied. My ex-boyfriend, who was domestically violence, beating me up or whatever, he beat him up. I lied and said that my son was the aggressor so that my boyfriend wouldn't go to jail. That's why this order is on him. I want to help my son go to treatment. I have somebody going in there from Northwest Resources to assess him. He just should not have this order. Like, I need to be able to help him, and I lied. I'm not with my boyfriend anymore, but I lied and I put my son in jail for that. And made him have no contact order because I, instead of doing the right thing and telling the truth about my boyfriend.
Yeah. This is what I'm going to do. All right. I am going to set the hearing that the prosecutor requested. I'm not going to make a decision on the no contact order. I know you probably firmly believe everything you told me, but right now, it's not the time to remove that order. But I'm going to have you get in touch with the city's domestic violence advocate and explain this to them, because that information that you're talking about right now.
Now hold up, enter the mother. Emotions flood the room. She drops a bombshell confession. She lied. That no contact order on her son, based on false claims to protect her abusive boyfriend. She pleads to lift the order, calling for treatment instead of punishment. Raw. Real, powerful. Her voice trembles, but her message is clear. I messed up. I want to fix it. The court listens, but it's not that simple. You don't just erase damage with words. She's told to go through official channels and prove her case. Welcome to real justice.
It kind of needs to be done through that process, and if there's any chance that the city believes that an injustice has been done, a wrongful conviction or something like that, then they can take the appropriate steps to undo that. But the way to do that isn't just to come into open court and start talking about it, okay?
I don't know. I thought I filed what I needed
I'm
to. I'm
not
sorry.
faulting you for that. I'm just telling you the right way to do
Okay,
it.
thank
that
you.
Could potentially, get you to where you want to be, which is you're going to go to talk to John Kill, and then they will help you with the rest of it, and then we'll address your no contact order. Okay. And I can give you their number.
I have it right
Oh, you do? All right. Brenda's got it for
there.
you.
Okay.
And if you'll come and get that,
Okay.
you
Right
can,
now?
Yep.
Okay.
Just come right on up, and you can call and sit down with. Yep. There you go. In the meantime, Mr. Sharp, do you have a suggestion about when that next hearing should be set?
I defer to Ms. Langley there. She may have a better gauge than the city would, Your Honor.
Okay.
When, Your Honor, I mean, maybe just after the upcoming pretrials on the other cases?
Okay. Yeah, they're coming up next week on Tuesday, so we could go and we could put this on your.
Things move fast. No time for sentiment. The court sets a follow-up hearing, giving the mother a shot to prove her truth. A domestic violence advocate will review her claims. The system's not cold, it's cautious. They don't gamble on hearsay. Meanwhile, the mother is desperate to get her son evaluated and treated. She's connected with someone from Northwest Resources. There's hope, but it rides on the next hearing. This court isn't about emotional pleas, it's about process, facts, and due diligence. The courtroom clears the air, no shortcuts, no side doors. Next voice 3.
We can put this on one of your in custody calendars next week.
Yeah, maybe
I mean-
Thursday. That give me a chance to.
So the 8th.
Yes, please.
Okay. All right, we'll do that. And you are welcome to be here for that. In fact, after you talk to John Kill, that may be the time to address your order too.
Okay. When is it? Sorry.
Next Thursday at 1:30.
Okay, I'll be here.
Okay.
Okay. And so who do I talk to about getting him I have somebody going there to do a treatment evaluation from Northwest Resources.
You can also talk to her about
That versus this right here? Okay. Okay. Thank you.
Today you are here in court for your first court hearing and arraignment on a charge of disorderly conduct alleged by the city of Lacey to have occurred on January 31st. Did you get a chance to talk to Ms. Langley about your rights?
Me, a cop car.
Did you get a chance to talk to Ms. Langley about your rights?
Did. And she was well clear about them. I understand them, but in a way, as far as the order goes, what I ordered was an ambulance, and they ordered me a cop car, and that is what the mistake that right aid, whoever that person is that represented them, made a mistake on.
Ms. Langley, let me go to you and see if we can clear this up.
A second bond drops, new charge incoming. The defendant's not just here for old business. There's a fresh accusation, disorderly conduct. The judge confirms the basics. But wait, the defendant flips the narrative. I called for an ambulance, he insists. They sent a cop. Tension spikes. Confusion builds. His attorney jumps in, but something's off. Communication's scrambled. He doesn't understand his rights. Now the court considers ordering a mental evaluation. This isn't just criminal, it might be clinical. The system pauses to assess. Is he competent to even stand trial?
Your Honor, I spoke to him at length. I was not able, I don't believe I was ever able to reach communication with him. I don't believe he understands his rights. I don't think he understands the charge.
I understand.
And
I'm ordering.
I'm asking for an evaluation.
Thank you.
Yeah. All right. And let's see. When did Mr. Panis, when did he get brought in?
Last night.
Yesterday at about 9 o'clock. Do you think maybe another night's rest and clearing up might help, Ms. Langley?
Worth a try, Your Honor, although I think the nature of the conversation was, it was more than just superficial confusion, but sure, maybe we could bring him up tomorrow.
And There's no probable cause determination on this. Is there any stipulation?
Longer.
I can, well, maybe I'd best not. Why don't I have the city?
Let me just check here. Yeah. All right, Mr. Sharp. Do you swear the testimony that you give in this matter will be the truth, the whole truth, and nothing but the truth?
I so swear, Your Honor.
Okay. Mr. Probable cause then.
This information comes from the report of Officer Vallela of the Lacey Police Department. He writes that on January 31st, about 8 p.m., he was dispatched to disorderly conduct. Advised he was contacted by the manager. She stated there was a male in front of the store screaming at customers. Officer Vallela arrived.
Customers, I was screaming at nobody. Please get that corrected. I was at the corner of the outside.
I wonder if we could.
I just had Mr. Panis's microphone muted because he won't stop interrupting. And so, Mr. Panis, I'm limiting your ability to participate and interject in the hearing because you're not able to control yourself. So, Mr. Sharp, would you go ahead and continue?
Thank you, Your Honor. Again, as Officer Vallela writes, upon arrival, he contacted Rite Aid staff. They advised that they wanted the male to leave, and he refused to do so. And if he refused to do so, they would like him trespassed. Officer contacted the male on the stairs in front of the store. He stated his name was Charles, but mumbled his last name. Officer asked what his last name was again. He again mumbled.
Now buckle up. Here comes the incident breakdown. January 31st, 8 p.m., Lacey, Washington. A man screaming at customers in front of Rite Aid. Cops respond fast. He refuses to leave, refuses to ID himself, gets louder, more erratic. The officer warns him, still no compliance. The situation escalates. Then, boom, he walks into oncoming traffic, disrupting vehicles across both lanes. A complete street side meltdown. This isn't minor mischief. It's full-blown public endangerment. Officer tries to de-escalate, but the chaos continues. Eventually, backup arrives and he's detained, but it's far from over.
Officer advised him that he couldn't hear him, asked if he could speak louder. He started to yell and swear. Officer advised the male that Rite Aid did not want him on their property due to him yelling at customers. He continued to yell at the officer and refused to leave. Officer advised the male that if he didn't leave, he would be trespassed. He continued to yell and swear at the officer while refusing to leave. Officer asked the male for his name again to fill out the trespass form. Again, he refused and continued to yell and swear at the officer. Officer advised the male that he would be trespassed as a John Doe if he continued to refuse to identify himself. While the officer was walking to the patrol vehicle to fill out a trespass form, the officer observed Mr. Panis walk across Yelm Highway and causing traffic to stop. He then observed Mr. Panis in the middle of the inside and outside lane of westbound traffic on Yelm Highway, screaming at vehicles, causing cars to both lanes to stop. Then walking westbound in the outside lane, officer observed many cars having to stop and switch to the inside lane while he was walking in the road. I'm going to skip ahead here just to the identification procedure. So the officer detained the male for disorderly conduct. He continued to yell, but then started to calm down. Second officer arrived and assisted with the physical detention. He was read his Miranda rights and he invoked. Officer Rosas arrived on scene. She advised that she was familiar with Mr. Charles Panis from previous encounters. She identified him and as such, and that was confirmed against DOL records with a photo match. CC probable cause for one count of disorderly conduct.
All right, I'll find probable cause for disorderly conduct. We'll set over Mr. Panis's arraignment to tomorrow afternoon at 1:30 and see if he's in a different frame of mind before we decide on whether to order a competency assessment. All right, Mr. Panis, we'll see you tomorrow afternoon.
Final act. ID confirmed, charges locked. The man mumbles through questioning. He's detained, Mirandized, and identified by a second officer familiar with him from prior run-ins. It's Charles Panis. His file matches the face. Game over. The judge rules, probable cause found, but still, something's not sitting right. The courtroom decides to delay formal arraignment by a day. Maybe a night's rest clears his head. Maybe not. Either way, this court isn't rushing. Justice is precise, deliberate, and unrelenting. Tomorrow brings round 2. And trust us, this saga is just beginning.